You are back on the Legal Line with Dennis Kennelly and my very special guest, entertainment attorney Holly Browdy. And just if you're wondering who the music is, it is a band of which I am very, very proud because I'm lucky enough to manage them. And that is London Rain. They're Cleopatra recording artist. And their second album will be out in about 2 months. It's going to master, and we're really, really proud of it. So keep your eye out for our new album, Confessions, which should be fun. Holly and I were discussing who gets a piece of what of the money pie involving any particular song. Now, Holly, you used a couple of terms that most people probably don't understand. First of all, what's a music publisher?
A music publisher is someone who will administer the bundle of rights that constitute the copyright in a musical recording, a musical composition. It's a little bit complicated because the terminology is somewhat confusing. For every dollar that comes in, payable as a result of what everyone considers quote-unquote music publishing, 50 cents of that dollar is what's called the publisher's share of income, and 50 cents is what's called the writer's share of income. So, for example, if you make a deal with a music publisher to publish your songs, and you give them a 50-50 co-publishing deal, that means that you get 50% of the 50 cents that is the publisher's share.
So I get a quarter.
A quarter, and if you are assume you are the sole writer, you get the entire 50 cents that is the writer's share. So then that would be referred to in the business as a 75-25 co-pub deal.
Now, is that the kind of deal, for example, that Taylor Swift would get?
At this point?
No, she'd probably get a 95-5, right?
Well, it wouldn't be a 95-5. What she could certainly get would be an administration deal. An administration deal is where the publisher does the mechanics of administering the work. They take requests for licenses, they issue clearances, they send you royalty statements, they audit people who need to be audited, but they do not, in fact, own any portion of the copyright. That is pretty rare. Ideally, a new writer in Nashville may very well be offered a publishing deal where the publisher takes 100% of the publishing, meaning that a dollar comes in, 50 cents goes to the publisher, 50 cents goes to the author. Preferable is the 75-25 deal where the writer retains half of the publishing. Better still is a reversion deal where after a certain number of years or after a certain amount of recoupment, the part of the ownership or all of the ownership of the copyright reverts to the artist. And this gets a little more complicated because it not only has to do with the issue of control and the issue of who gets the money, but if later on in your career you have a large catalog and you want to sell your catalog, you can only sell what you own.
Exactly.
So, the more of it you own, the better. And there are a lot of veteran acts who have managed one way or another to obtain reversion. Sometimes an artist can get reversion because he or she has been very successful and the publishing company's term is over and the publishing company wants to re-sign that writer. And that writer says, well, the only way I'm going to do it is if when the term of the extension is over, I get reversion, including on the songs that I first gave you. So they retroactively modify the publishing agreement. And there are a lot of reasons why the publisher would be willing to do that. Obviously, because it's a source of vast income, but also because it's prestige. And if you have Taylor Swift, and then 3 years into her career, Taylor Swift leaves and goes to another publisher, it makes you look bad. So you are better off sweetening the original deal you made with Taylor Swift in order to extend the deal and keep that writer.
Absolutely. Now, is it the publisher's job to scout out the recording contract or not?
It is not.
Who does that?
Well, generally, the manager would scout it out. The problem is that it's very difficult to get a high-level manager interested in you until you have had some success. Now, a lot of it will come through social media. So if you have a big enough following on social media, people will start noticing you. It can come through, connections. I mean, when I was at Polygram, Skid Row was a band that John Bon Jovi had heard playing in a club in New Jersey somewhere and thought they were terrific and brought them to various people. And obviously, because it was John Bon Jovi, attention was paid, and the band was indeed terrific, and they were promptly snapped up and signed. Last week, I was at a showcase at a small club in L.A. For a very, very good artist who has been getting interest from publishing companies, and he hasn't yet gotten interest from any record labels. But what will happen in a case like that is that the publishers, once a publisher wins the war to sign him, because people in the industry talk to each other all the time, somebody at a record label will hear from a friend of theirs at a publishing company that they just signed this guy and that he's really good, and so then the labels will get in on it.
Exactly. Who are the big publishing companies now, if anybody is interested in seeking out a song publisher?
I really would hesitate to say, because there are advantages and disadvantages to everything, and I think some of the very largest publishing companies are not a good place to be. I have a client who just had a situation with a publishing company they've been signed to for a very, very long time, and the publishing company basically does nothing. And the artist finds infringements and pursues the infringers. First, the artist notifies the publishing company. The publishing company does not even bother to respond. The artist will then take action against the infringer. Now, the publisher, because the publisher actually holds the rights to administer the publishing, has to sign off on any kind of a settlement deal. And I've actually had trouble convincing them to forego the settlement amount that is paid to the artist. I've ultimately gotten them to, but they don't really understand why they shouldn't get a piece of the settlement when, in fact, it's their publishing rights. Even though they haven't enforced them, they've done nothing, and the settlement wouldn't have existed at all had the band not spent substantial time and legal fees in bringing it into being.
Well, let's say that let's take, for example, London Rain. We had a distribution deal with Cleopatra, which was nice, and we're gonna get a better deal with them or somebody else, more than distribution, the next time around. Mm-hmm. But let's say this time I own all of my company owns all the publishing rights to London Rain songs. Mm-hmm. That's clear. We won't give those away to anybody. And for example, was Disney ever a publisher when you were there?
Oh, absolutely. Disney has a publishing division. It's called Disney Music Publishing. They have an extensive catalog. They have obviously a lot of it is Disney-related product, but they have other things too. They have popular songs. They have Miley Cyrus songs. They have Demi Lovato songs. There's a tension always in a situation like that because the writers want to have a real publishing deal where somebody is going to fight to get them the best prices on synchronization licenses, for example. And a company like Disney, where they are making deals and licensing the masters, and things are very intertwined, so, you may have a Monsters, Inc. singing toothbrush. What you'll have is you will have one division that licenses the masters to the toothbrush manufacturer to use for the singing toothbrush, and what people often don't understand is that the rights to the underlying composition are something separate. They're not included. If I license the recording of Frank Sinatra singing My Way, that does not mean that I automatically have the rights to the song. I then have to go to the publisher who holds the rights to the composition My Way and get a license from them as well before I can use it. So really for any kind of audio recording, there's the rights in the master and the rights in the composition.
And in the case of My Way, Frank Sinatra did not write that song. I forget who did. But you have to go to the songwriters, don't you?
Correct. Well, you have to go to the publisher who administers. Now, usually, because administration involves a lot of, not terribly glamorous and somewhat burdensome things like audits and records and issuing licenses and following up on things and calendaring to see when the term of the synchronization license for that radio commercial ended. Usually what will happen is even if one publisher, even in a 75-25 deal where the writer has the entire writer's share and half of the publisher's share, and an outside publishing company has the other half of the publisher's share, usually the outside publishing company will have what's called administration rights, meaning that they will, quote-unquote, administer both their 25% and the writer's 25%, or 50-50 if you're talking about just the publishing share. It's much easier that way. What it means is that one entity can speak on behalf of both the publisher and the writer's publishing company. And this can become a real problem.
I can imagine.
Well, the weirdest situation I ever ran into was back when I was at Polygram, and the sampling had really taken hold. And so what you had was you would have a composition that had 4 different writers, and that would be sampled in another composition that had 4 different writers, and then the writers of the original composition would sue the people who had sampled it, and then usually the result is that you end up owning a share of the composition that sampled your composition. So now what you have is you have a composition with 8 writers. I have seen compositions with 14 and 15 writers. Now bear in mind that you not only have 14 different writers, but not all of these writers will be signed to the same outside publishing companies.
So who runs the show?
Well, that's kind of the problem. We had a situation once where we wanted to license a composition for a synchronization license, and generally for a synchronization license, because there's no statutory rate the way there is for a mechanical license, you have to get the okay from every publisher who has a piece of it. Literally, on this rap song, there was a writer who had 2% of the song. The way that he had ended up with 2% of the song was I kid you not, the guy that delivered pizza to the studio. The band was kicking the song around and was looking for some sort of rhyme, and the guy said, "Hey, what about this?" And they said, "Great!" And now he has 2% of the song. And literally, if the other 98% want to license the song for $100,000 for use in the next Transformers movie, and the guy who has the 2% doesn't want to do it, it can't be done.
So you better keep an eye on to whom you're promising a piece of your song.
Absolutely. Absolutely. And you know, you can give away a piece of the song without giving away the administration rights, because a lot of times, for example, you'll have a record producer in the studio with a band, and the producer will end up co-writing things with the band. So what the band wants is clearly they've got to, they can't take the producer's publishing, but what they can do is they can have a provision in his production agreement that says, you know, you have this piece of it, but we have the full right to administer it. We can issue licenses for the whole thing, so you basically get your income share.
Yeah, it's basically like a stock proxy.
Mm-hmm. It is, yeah, very much like that.
So, yeah, and that would save a lot of trouble, and our 2%er would not be holding up progress on our $100,000 deal.
Well, and, you know, you also, sometimes people vanish. Musicians are not necessarily the easiest people to keep track of.
I've heard that.
Yeah. You have somebody in a band and they write a piece of a song and then they leave the band and maybe they're not on good terms and they want to hold things up, or maybe they leave and they are on good terms but they've, you know, moved to the UK and you can't find them. It's a lot easier to find people now with social media, but it used to be a real problem.
Oh, I can imagine that. I mean, I remember the days of going through the white pages.
Mm-hmm. Absolutely.
For those of you who've never seen a telephone book, the residential listings are in the white pages. I assume they still print telephone books.
I think they do, but I'm not sure what anybody uses them for.
Absolutely. Even I converted about 3 years ago, and I was one of the last holdouts.
I think they're still good if you have a chair that's slightly too low, you can put the telephone book on it and sit on it.
It works. Folks, get out your pencils, put down two numbers, 661-298-5487. That's the number to talk to us and myself and Holly, and ask any entertainment or employment law questions you have. The second one, write down my website, which is which is DennisKennelly.com. Kennelly is Kennelly, and you can find out my phone number, because I'm willing to consult with you, give you a half hour free on the phone. So, and that's how we find out if you've got a case or not. So we will. We've got about 5-6 minutes to go actual time after we come back from this break. You are listening to On the Legal Line with Dennis Kennelly and my guest Holly Browdy. Welcome back. You're on the Legal Line with Dennis Kennelly and my very special guest, Holly Browdy. And we're talking all things copyright and music and money, which is always fun to discuss. Interesting question. We go back to, I'm not a solo singer-songwriter anymore. I'm with the band. And but I write all the stuff, or I write most of it, and we get some contribution from other band members. And let's say we have an agreement that works so that we know on any given song, we don't fight about it, we know who contributed what as far as the writer's share is concerned. And we have an agreement as to what to do with the publisher's share. So, you know, that should put us ahead. But what happens when it's record company time and our manager is sharp enough to get us a record deal? Now, and the record deal is that it's the song that's bought. It's you know, they buy the song, not the singer, so they get somebody else to sing it. That's one. Let's do that one first. Now, who gets a piece of that when we sell the song?
Well, what is the arrangement that you've come to with the rest of the band? I mean, you may have written the entire song, but is there any agreement that the entire band shares the publisher's share?
Okay, let's say if we have an agreement, that's good. There's no dispute. But if there is a dispute, if there is no agreement, who gets the publisher's share?
If there is no agreement, the person who wrote it would get the publisher's share. Because the ownership, absent an agreement, the ownership of the copyright follows, percentage-wise, follows the portion written. So, for example, if you write the music and the lyrics, you will, from inception, own 100%. If you write the music and I write the lyrics, we will each own 50%. If, you write the music and I write the lyrics with my best friend and I will each own 25% and you will own 50%, and so on and so forth. Now, obviously, this doesn't always work because maybe you have 4 people, but one of them only contributed 5%. That's when you have to work it out by agreement. But absent an agreement, if you wrote the whole thing, you would get all the money.
And I think what this tells us is, and I do this when I'm working with bands, is you get all this agreed upon up front because nothing is worse than litigation.
Oh, yeah.
Litigation is a pain in the neck, respectfully to the profession in which we both engage. The big winner are the lawyers, unless you're dealing with Taylor Swift stuff. And there's a simple way to do it, which is to come to reasonable agreements at the start so there are no secrets.
You also, I saw a situation recently where there was a fairly popular duo, and this was a while back, and they had some success, and they had been boyfriend and girlfriend, and then they had an unpleasant breakup and were no longer speaking.
Ah, yes.
And because this had not all been sorted out and committed to writing beforehand, the one of them who wanted to release some tapes from the vault couldn't release them because the other party would not agree to sign off on the publishing.
Ah,
so
yes.
Sometimes it's not just a question of who gets the money, it's a question of whether you can take advantage of the opportunities at all.
Yes, and sometimes egos get in the way of money. That's been known to happen.
Really?
I've heard rumors to that effect. Okay, now let's go. Here's the final thing before we have to cut this off. But let's deal with the scenario where a recording that the band makes of a song is sent to the record company, and the record company really likes it, and they say, this is great, but we don't want the band, we want you singing it, Mr. Singer-songwriter and lead singer of the band, but we're going to back you, we're going to get trained musicians to do this with you. Now, did the original band members, absent an agreement up front, are they entitled to anything for performance rights or anything on the record?
If the master isn't used,
yes,
they are not entitled to anything.
Okay.
And this actually is, comes up a fair amount because you'll have a band that's looking for a record deal, and they'll send in the demos, and the record company will say, hey, we really love the band, but we, hate the bass player.
Exactly.
Get a new bass player. And, then the band has to decide, do we all hang in there together? Do we turn on the bass player and jettison him?
Speaking of jettison, unfortunately, our time has just been jettisoned. Holly, I really want to thank you. Look forward to having you on as a guest in the future. You've been on The Legal Line with Dennis Kennelly, and you're on KHTS. Thank you very much.